All right, welcome back, everyone. If you've been with us through weeks 1, 2, and 3, you've built a strong foundation in creating AI-assisted content. You know how to define why content exists before you create it. You know how to plan for the right reader in the right moment, and you know how to write with clarity, story, and structure. Guardrails are what help you know exactly where the lines are and build content systems that never cross them.
Let's place today in the context of the larger framework. We've moved through strategy, planning, and craft. Today we're at guardrails, the fourth phase. And if you look at where guardrails sits in this diagram, it's positioned deliberately between craft and refinement. Guardrails don't come first because first you need something to constrain. You need a draft, a plan, a voice. But guardrails come before refinement because there's no point polishing content that crosses a line. You refine what survives the guardrail check, not the other way around. The outcome at the bottom of this diagram, trusted authoritative content that serves human needs, only holds if trust is actually earned. Content that exaggerates, overpromises, or sounds like it came from a template generator is not trusted content. It's the opposite. What lines can this content never cross has three levels. The first level is legal and regulatory. What rules, bar rules, FTC guidelines, medical board standards explicitly prohibit certain kinds of content? Those are hard lines, and we'll walk through the specific ones that apply to your industries. The second level is ethical. Even when something is technically permissible, is it honest? Is it fair to the person reading it? In legal and healthcare marketing, especially, the people you're trying to reach are often in vulnerable situations. They deserve content that respects that vulnerability, not content that exploits it. The third level is brand. Generic AI output that sounds like every other law firm or medical practice isn't just unhelpful, it's actively corrosive to the trust and differentiation you've worked to build. Today, we're going to cover all three levels.
Legal and regulatory requirements are the floor, the non-negotiable baseline every piece of content must clear before anything else is considered. For attorneys, that means understanding how bar rules follow you onto your website. For healthcare providers, it means knowing where FTC guidelines, FDA standards, and state medical board rules intersect with the content you publish. This section walks through the specific rules that apply to your practice, the categories of claims that create the most exposure, and how to build a review process that catches problems before they become complaints.
A lot of practitioners assume that marketing content lives in a different category than professional conduct, that the bar rules or medical board standards that govern how you advise clients and treat patients don't follow you into your blog or your FAQ page. That assumption is wrong, and it's the assumption that creates the most exposure. For attorneys, ABA Model Rule 7.1 is the governing standard, and it's broad. It prohibits any communication about a lawyer's services that is false or misleading, and misleading includes content that creates a false impression, even when nothing in it is technically untrue. A page that lists your verdicts without mentioning that several were later reduced on appeal isn't lying, but it is misleading. The rule doesn't distinguish between content a human wrote and content that is AI generated. If it's on your website under your name, you own it. For healthcare providers, the framework is different, but the exposure is similar. The FTC Act's prohibition on deceptive practices applies to healthcare marketing. The FDA governs any promotional content that names or implies a specific treatment or drug. And state medical board advertising rules, which vary considerably but tend to share a common thread, govern how you represent outcomes, credentials, and services. Most of these rules share the same standard we mentioned in week 1. The question isn't whether something is technically accurate, it's whether it creates a false impression in the mind of a reasonable person reading it. Here's what that means practically. When you use AI to draft marketing content, the AI doesn't know your state bar's advertising rules. It doesn't know whether your jurisdiction requires a disclaimer on case results, or whether your medical board prohibits before and after imagery of certain procedures. or whether your state has specific rules about attorney testimonial that differs from the model rules. It produces confident, professional sounding text that may be entirely compliant or it may not be, and it has no way of telling you which. That's not a reason to stop using AI. It's a reason to build a review step that includes someone who knows the rules.
Thank you, Jen. That's such a good point. And I'd like to point out for the foster clients who have content services, our writers rely heavily on Jen's expertise as an attorney. Jen does a wonderful job of helping make sure that we follow all of those ethical guardrails ourselves. All right, there are three specific categories of claims that are going to come up repeatedly in AI-assisted legal and healthcare content. And they're worth naming individually because they're the ones that are most likely to generate a bar complaint, a regulatory inquiry, or an FTC warning letter. The first is an outcome claim. If you say something like, we recovered over 50 million for our clients, or our patients report a 75% reduction in pain after this procedure, both of these sentences can be true and still be problematic. Aggregate outcome figures create implied expectations about individual results. Most state bars require a disclaimer along any case result advertising, something to the effect that past results do not guarantee future outcomes. Many require that the disclaimer be as prominent as the claim itself, not buried in footer text. AI will generate the claim, however, it will not generate the disclaimer unless you specifically prompt for it. The second category is the superlative, the most experienced personal injury firm in the region, the leading provider of minimally invasive spine surgery in the state. These are comparative claims that are only permissible when they can be objectively verified. Most experienced by what measure? Verified by whom? Most firms and practices using superlatives in their marketing have not done the work to substantiate them, and AI generates them freely because they appear constantly in the promotional text that's used in its training data. Every superlative in your content should be challenged. Can we actually verify this? If the answer is no, it comes out. The third is the specific advice disguised as general information. This one is a little subtler and in some ways more dangerous because it doesn't announce itself. It happens when a blog post that starts as an educational overview of medical malpractice gradually shifts into language that implies the reader should take a specific action regarding their individual situation. Or when an FAQ about shoulder surgery starts recommending specific procedures for particular symptoms. AI is prone to this because the training optimizes it for helpfulness. And the most immediately helpful thing it can do is give the reader specific guidance. The problem is that this specific guidance requires a professional relationship, a full assessment, and all of the guardrails that come with those things. A web page alone cannot provide them.
I want to be practical here because the goal isn't to make everyone anxious about their content. The goal is to build a review habit that catches these issues before they become problems, and to do it in a way that doesn't require a regulatory attorney to sign off on every blog post. The most effective approach I've seen is a tiered review system, recognizing that not everything requires the same level of scrutiny. A post explaining what to expect at a first orthopedic appointment carries different risk than a page advertising case results or clinical outcomes. A general FAQ about how workers' compensation works carries different risk than a page promoting a specific surgical technique. Your review system should reflect that difference. For lower risk educational content, such as general explanations, condition overviews, process descriptions, a trained staff member working from a clear editorial checklist can handle the review. That checklist should flag outcome claims, superlatives, and specific advice. For higher risk content, anything featuring case results, clinical outcomes, testimonials, comparative claims, or content about specific treatments or legal strategies, a licensed professional should review before publication. And for both categories, build a documentation habit. Keep a record of who reviewed what and when. If a bar complaint or regulatory inquiry ever comes, the ability to show a systemic review process matters. It demonstrates that you take your professional obligations seriously, which in many cases is the most important thing you can demonstrate.
The ethical level of guardrails asks a harder question than compliance. It's not about whether your content is permissible, but about whether it's honest, fair, and genuinely useful to the person reading it. The people who are finding your content are often in vulnerable moments. They're frightened, they're in pain, and they're uncertain about their options. They are looking for someone they can trust. How your content treats that vulnerability, whether it serves it or whether it exploits it, is an ethical choice. And it's a choice that no checklist alone can make for you.
So let's consider the reader on the other side of the search bar. The ethical dimension of content marketing becomes much clearer when you stop thinking about it abstractly and start thinking about who's actually reading. A potential client who searches, "Can I sue my employer after a workplace injury?" is probably not doing research for a law school paper. They were hurt. They may be out of work. They're likely scared about money, uncertain about their rights, and trying to figure out whether it's even worth pursuing anything. They're in a vulnerable position, and they are bringing that vulnerability to your website. A patient who searches, "What are the risks of spinal fusion surgery at 11 p.m.?" is probably not casually curious. They've received a recommendation. They're weighing a frightening decision. They may have already been through one failed treatment. They're trying to find someone they can trust to give them an honest answer. The ethical guardrail is simple to state, but requires constant active attention. Your content should serve that person, not take advantage of them. There's a real difference between content that helps a frightened person understand their situation and make a clearer decision, and content that's engineered to convert their fear into a phone call before they've had a chance to think clearly. The first builds the kind of trust that sustains a practice over time. The second may generate short-term conversions and long-term reputation damage. AI does not make this distinction. It is optimized for engagement and persuasion. The ethical judgment about when persuasion becomes exploitation is entirely yours.
Imagine a piece of content that you're considering publishing, something that AI helped you draft that's polished, professional, factually accurate, and legally compliant. Before you hit publish, I want to ask you one more question. If the person this content is written for read it at their most vulnerable moment, would you be comfortable with how it made them feel? This question is going to be harder than a compliance checklist. It requires you to inhabit the reader's experience and not just verify the content's accuracy. Let's talk about a specific example. An attorney's website includes a section on wrongful death claims. The content is accurate. It cites the correct statute of limitations. It includes the required disclaimer about past results. Legally, it's clean, but it opens with a paragraph designed to create urgency. Language about how quickly evidence disappears, how insurance companies are going to move fast to protect themselves, and how waiting even a few days can hurt a case. Every one of these statements is technically true, but together they're calibrated to create anxiety in someone who is grieving. Is that permissible? Probably. That's a harder question. Is it right? This is the question that the ethical guardrail asks you to sit with. This isn't an argument against urgency or persuasion in content. There are situations where urgency is genuinely relevant, and the reader is better served by knowing that time matters. The distinction is between urgency that serves the reader's interest and urgency that serves your firm's conversion rate. Your content strategy should always know which one it's reaching for. The practical application here is going to be to read your content not just as a professional verifying accuracy, but as the actual person it's written for, in the emotional state that they're likely to be in when they find it. This perspective shift catches things that a compliance checklist misses every time. And just in my own experience as a writer, I'd like to point out that this is kind of relevant to the grandpa test that we talked about last week. I think it's really important to think about how you would feel if someone that you cared about who was vulnerable was reading the content, and how you wouldn't want them to be misled. You would want them to be treated fairly. Kate, as a writer, do you have any tips when you're writing to help you create ethical content that you can share with us?
Yeah, I was actually just thinking about that. One of the things that I would look for would be anything that was like a triggering word, something emotional, like something that inspires, especially fear or anxiety. Um, and just double check it.
Yeah, I think that makes sense. What about you, Jen?
Yeah, I would agree with that. I mean, think back to what our goal here is, which is to provide educational materials that lead to calls, right? So that you
Hmm.
can give individual advice. What you don't want to do is appear as the old time ambulance chasers, right? That have the bad reputation for legal marketing. Um, if you think you're taking advantage of someone, stop and read it again.
Yeah, being cautious is always the best approach. I guess that's our key takeaway for today. When in doubt, take it out.
Okay, there's a version of ethical content that goes wrong in the opposite direction from the examples we just described. Instead of exploiting vulnerability, it hides from it. Behind so many disclaimers, so much hedging, so much consult a qualified professional for your specific situation language that it stops being useful to anyone. I've seen healthcare websites where every other sentence contains a variation of results may vary or this is not medical advice. I've seen law firm blogs so heavily qualified that a person trying to understand whether they have a valid claim finishes the article knowing less than when they started. That's not ethical restraint. That's a different kind of failure, one that abandons the reader under the guise of protecting the practice. The ethical standard we're working toward is honest usefulness. Your content can be genuinely informative, clear, and helpful, and still have appropriate guardrails. Those things are not in tension. The goal is to give the reader what they actually need to move forward while being honest about what a web page can and cannot provide. What that looks like in practice. Lead with the most helpful information you can give at a general level. Be clear about where individual circumstances create meaningful variation, not to hedge your way out of saying anything, but because it's genuinely true and the reader deserves to know it. Then direct them clearly toward the professional conversation where their specific situation can actually be assessed. That structure, informative, honest about limits, clear next step, is both ethically sound and strategically effective. It serves the reader and it serves the practice. And it is exactly what AI, prompted well and reviewed carefully, can help you build at scale.
And I think if you're looking for a really specific guideline for how often you can say something, as a writer, I like to say about 3 times per article is usually sufficient. If you want to repeat something that results may vary or that you should see a doctor or see an attorney. Once in the beginning part of the article, once somewhere in the middle, and then again towards the call to action. Is that something that you apply in your own work, Jen?
Yeah, I think that's exactly right. Anywhere you mention case results or testimonials is usually a good place to stick it in. Um, but yeah, three sounds right.
Yeah. Okay. So when we're talking about brand, we have to keep in mind that legal compliance is what keeps you out of trouble. Ethical content is what earns the reader's trust. But that third guardrail is going to be the easiest to dismiss under pressure, and it's going to be quietly more damaging when you ignore it. We consider brand a guardrail because generic content isn't neutral. Every blog post that sounds like it could have come from any firm in your market, every FAQ that reads like it was assembled from a template, or every service page that hits the unexpected notes without saying anything specific is a small withdrawal from the authority and differentiation that you're trying to build. The damage doesn't announce itself, it slowly accumulates. And by the time it's visible, it's already shaped how your practice has perceived, or more precisely, how it isn't.
When your website sounds like every other firm or practice in your market, same phrases, same structure, same reassuring but vague claims about compassion and experience and commitment, you give a prospective client or patient no basis for choosing you over a competitor. They make that decision on price, on proximity, on who shows up first in search. You've handed away the one thing content can do that paid advertising can't: communicate who you actually are. It costs you trust with the audiences who matter most. Sophisticated clients, the ones making significant decisions about complex litigation or serious medical procedures, are very good at recognizing generic. They've been to enough websites. They know what a template sounds like. When they encounter it, they move on. The audience you most want to reach is often the audience most sensitive to authenticity. And over time, it costs you authority. Google and AI answer engines are getting better by the day at distinguishing content that reflects real expertise from content that reflects pattern matching on existing text. Content that sounds like everything else tends to perform like everything else, adequately, generically, in the middle of the pack. Content with a genuine point of view, a specific voice, and real expertise behind it is what earns the featured snippet, the AI citation, and the first position organic result. Generic isn't a safe choice. It's a slow erosion. And because it happens gradually, a blog post here, an FAQ there, each one fine on its own, it's easy to miss until it's done significant damage.
Brand voice is one of those terms that gets used constantly in marketing and is rarely defined. So let me be specific about what this means in the context of a law firm or a medical practice, because it's different from what it means for a consumer product company. For a professional service, brand voice isn't primarily about personality, whether you sound warm or formal, serious or approachable. Those things do matter, but they're downstream of something that's more fundamental. Brand voice for a law firm or a healthcare practice is the expression of a specific point of view about your field, your clients or patients, in the work you do. It's in the way your founding partner explains a diagnosis or a legal strategy to a patient or a client who's nervous and confused. It's in the particular things your firm believes about how cases should be handled. It's in the types of clients that you've chosen to serve and the ones you believe should be referred elsewhere. It's in the stories your staff tells about why they've chosen to do this type of work. Here's a practical exercise. Before you write another AI prompt, write down 5 things that are true about your firm or practice that would not be true of 3 of your closest competitors. Not, we're experienced or we care about our clients, specific things. Then build those specifics into every prompt that you write. That's where distinctive content comes from. Not from AI, but from the brief that you give it.
Okay, let's talk about creating a brand voice document. Every AI prompt you write is a briefing document. The quality of what comes out is directly proportional to the quality of what you put in. And the single highest leverage thing you can add to any prompt, the thing that moves AI output from generic to genuinely useful, is a clear, specific description of your brand voice. I want to walk you through what a useful brand voice document actually contains, because most of what gets called a brand voice guide is not useful for AI prompting. A list of adjectives, professional, compassionate, authoritative, tells an AI almost nothing it doesn't already default to. A list of topics to avoid or statements like "don't use jargon" is marginally more useful, but still thin. What actually works is examples and contrasts. Show the AI what you sound like by giving it real samples of content that represents your voice at its best. A paragraph from a client letter you're proud of. A patient communication that got positive feedback. A blog post that reflects how you actually think about your work. Then show it what you don't sound like: generic AI output, a competitor's boilerplate page, overly formal institutional language. Add to that a description of your reader that goes beyond demographics, not just personal injury clients in Florida, but what those clients are feeling when they find you, what they usually already tried, what they're skeptical about, what a good outcome looks like to them beyond the legal resolution. The more specific and human your reader description, the more human the AI output becomes. And include your guardrails explicitly in the document. state clearly. We don't use superlatives we can't verify. We don't make implied guarantees. We don't give specific advice in published content. We direct readers to a consultation for their individual circumstances. When those guardrails are baked into the brand voice document rather than added individually to each prompt, they become part of every piece of content as a matter of course, rather than something you have to remember to enforce each time. That document is not a one-time project. It's a living tool. Review it when you get feedback, positive or negative, on content that felt particularly on brand or particularly off. Let it evolve as your practice evolves, and share it with every person on your team and every vendor who creates content under your name.
Right. Thank you, Jen. And just on a practical note, I'd like to point out that you don't actually have to attach all of these to every single prompt that you do in ChatGPT or Claude. It's going to be a lot easier for your content creation process if you create projects in Claude or custom GPTs. And then you can attach all of these examples to your files. The ones that we use on the Foster content team typically have between 10 and 20 documents attached to them. And our prompts are very lengthy, and so then they are all saved in there. But then when we're creating content, all we have to do is provide a general explanation of the topic, and it saves a ton of time to invest in setting up a good GPT structure. All right, I am missing a few slides for some reason here. So we're just gonna talk a little bit about photo and image ethics. This is something I think that most practitioners haven't thought carefully about because the visual side of content marketing often tends to feel a little lower stakes than the written side. It isn't. The images that are on your website are marketing communications in the same way that your written content is. And the same rules govern what you can say about what you can show. AI-generated imagery has created several new categories of risk that weren't on people's radar just a few years ago. The most serious issue right now, particularly in healthcare marketing, is the use of AI to enhance or generate results imagery. Before and after photos are among the most powerful tools in medical marketing, and they're also among the most heavily regulated. The FTC's position is straightforward. Imagery that creates a false impression of typical results is deceptive under Section 5 of the FTC Act, regardless of how that image was produced. If you're using AI to alter an outcome photo, it can be deceptive if the ad's net impression misleads consumers about the product's performance or about the results consumers can generally expect. The question the FCC asks isn't whether you used a tool, it's whether a reasonable person who's looking at that image is going to come away with an accurate understanding of what typical results look like. State medical boards go further in many jurisdictions, requiring that before and after imagery represent real, documented patient outcomes and be accompanied by a disclosure that individual results can vary. For attorneys, image risk shows up differently, but is equally real. If you're using a stock photo of a diverse multi-attorney team, when your actual staff doesn't reflect the image, that can generate bar complaints under state versions of Rule 7.1. The reasoning is exactly what you'd expect. A prospective client who hires a firm based in part on the impression the website has created has been misled, even if there's no individual sentence on the page that's false. Images create impressions, and impressions are held to the same standard as statements. And then there's a category that's genuinely new. AI-generated people delivering testimonials, synthetic video and audio of fictional patients describing outcomes, or fictional clients praising legal representation can be deceptive or misleading under FTC endorsement guidance. And in legal services context, this can violate lawyer advertising rules that prohibit false or misleading communications. There's no framing that's going to make this permissible, not a disclaimer, not a for illustrative purposes label, and not a terms of service footnote. The harm isn't just regulatory exposure. It's real to every patient and client whose trust you've worked so hard to earn, and damages the credibility of the profession as a whole.
Thanks, Dana. Let's talk about some practical image guardrails since we're talking about images. So, what does this mean in practice? A few specific guardrails worth putting in place now before images become problems later. First, any results imagery. Medical outcomes, legal victories, before and after photos must be real, documented, and representative enough that you can stand behind it as an accurate picture of what patients or clients can reasonably expect. Second, if you're using AI generated images in legal or healthcare marketing, whether for staff visuals, patient scenarios, or general branding, your safest approach is to disclose that clearly when the imagery could be interpreted as real people, real clients, or actual outcomes. While broad disclosure laws are still evolving, existing regulations already prohibit misleading representations. In both legal and healthcare contexts, using synthetic imagery that implies real individuals' experiences or results without clarification can raise compliance concerns under FTC advertising standards, state consumer protection law, and industry specific rules governing professional conduct. Platform policies are also trending toward greater transparency, particularly for realistic or potentially deceptive AI generated content. At the same time, regulators, especially at the state level, are increasingly focused on synthetic media in sensitive domains like health and legal services. Just as important, audience expectations are shifting. When people believe they are seeing real patients, clients, or professionals, and later discover the imagery is artificial, the resulting loss of trust can outweigh any efficiency gained from using AI. As a practical guideline, if an image could reasonably be interpreted as depicting a real person, client, patient, or outcome, include a clear disclosure, such as AI generated image or illustrative image. This helps reduce regulatory risk and reinforces credibility in industries where trust is essential. Third, and this applies to every image of a real person on your website or in any marketing material, it is best practice to get a written release, not a checkbox buried in your general intake form, a specific signed authorization that names the intended use clearly enough that the person signing it genuinely understands what they're agreeing to. For healthcare providers, that document needs to meet HIPAA's marketing authorization requirements, which are distinct from general treatment consent and carry their own specific standards. For attorneys, it needs to clearly capture the client's understanding that their image or their case result will be used in public-facing marketing. One signed document kept on file is the difference between a clear record of informed consent and a liability you didn't know you had until someone pointed it out. The line across all of these is the same standard we've been applying to written content throughout this course. Would a reasonable person come away with an accurate impression? If the answer is yes, you're on solid ground. If you're not sure, that uncertainty is the signal to pause before publishing.
Thank you, Jen. That's a really good point. And I'd also just like to point out that many of us tend to avoid hiring a professional photographer due to cost considerations, but it's often not as expensive as you might think. And I'm going to call on Kate here because I know Kate has quite the photography background. Kate, do you have any tips for us, for our readers who are budget conscious, how they can get professional images at an affordable price?
Sure. Yeah. Working with people who are pursuing a degree in photography would be a really good way to get more cost effective. Somebody who's almost fully trained has all of the knowledge that they need to create the images for you, but isn't fully established yet in their career. Another thing I was thinking about with the images, in addition to accuracy and and disclosing that it's AI generated, another thing to think about is images give us a feeling also, like just like text does, images can create an emotion. If the images create an emotion that isn't in keeping with what you want for the overall content, then that's maybe a red flag to reconsider that image choice.
I really like that. And your point about emotions and consistency, I often notice when I'm selecting pictures for content that our clients who've invested in a professional photo shoot, it's much easier to create that consistent brand across practice area pages. So I'd just like to urge you to consider photography an investment before you go too far down the rabbit hole of AI generated imagery. And finally, if you'd like to discuss content creation in more depth, Jen and I are always here to help. You can scan the QR code on the screen here to book a 30 or 60-minute content strategy session with us. And then, of course, we'd also like to invite you to join us at Foster's exclusive AI Mastermind. If you'd like to take your exploration of AI beyond content and start to use it in your intake, sales, and day-to-day operations, this is a smaller, more hands-on group where we talk about what's actually working right now, not just tools, but how to think about using them effectively. If you're in this course, you'll get a free 6-month trial to the mastermind. So keep an eye out on your inbox for that invite. If you don't see it, just reach out to us and we'll make sure that you're all set up. That's all we have for today. Thank you for coming.
Dana, I have a couple quick questions for you and Jen,
All
if you guys
right,
don't mind.
perfect.
I'm glad you brought up images because that was actually one of my questions, if images have the same standard. But in talking about the output, it can be very easy for someone who's asked AI to write content for them to just simply check if it's accurate. Will AI be factual in telling you, yes, I fact checked this, or no? Can you use AI basically to check the output, or should you really have a human do that? Does it matter?
That's a good question. We do use AI sometimes. If we have Claude generate content, for example, we'll run it through ChatGPT and ask it if there's any issues that we should be aware of. And oftentimes it will pick up things that we hadn't thought of, but we always do a human fact check as well.
Got
The
it.
Yeah, I would
technology
have
is
answered.
getting better, but it's not there yet where you can rely on it completely.
I agree. I would have answered similarly. We do both.
Mhm.
Um, when we put it through AI to fact check, I always ask it to give me the citation it's relying on, so then we can
Mhm.
go to the law or the case or whatever it is, to double check it ourselves.
Ah, great. Now, what if someone was to download all of their state laws and kind of load it as one of their, the document you talked about, the brand voice document? Is that still good? Do you think AI can output accurate data or should still be human checked?
Still
It
human
can reference
Got
pretty accurately. I've done that for a few select projects, but what I typically do is ask it to tell me specifically what page it's referencing in the document, and I will go back and manually check it.
it. So always a human involved.
Yeah.
Always.
And then I know we have a lot of people from different areas on here. Is there a site or a resource that you guys use to kind of check local laws, or how should someone kind of start building their own document of local laws to kind of keep in mind as they go through this stuff?
Uh, that's a good question. Honestly, I would say for those things, we rely a lot on our clients and their expertise whenever we have a question because we are not, well, Jen has a law degree, but she's not
Mhm.
currently practicing as an attorney. We always defer to our clients as the subject matter experts.
Got it. Fantastic. Awesome. Well, thank you. This was fantastic. Appreciate it, ladies. And Dana did this with a cold today, so she is an expert here. So thank you so much, guys. And any other questions? Otherwise, we'll get the recording out to you. Thanks so much.
Thanks.
Thank
Bye.
you.